Sure.
because I have started the recording. All yours.
Thank you, Kelly. I like to start with this slide to just acknowledge up front that these HR topics are rarely good news. So you probably already know that. You know, for proprietors and for GMs, employees seem to be gaining protections and rights, and employers seem to be losing protections and rights. And I understand that it's very easy to feel overwhelmed by HR compliance issues. It's a tremendous burden, and I know most of you don't have a person who's dedicated solely to HR. We've got the, Fair Labor Standards Act, salary issue up in the air, the Affordable Care Act, got our arms around it. Laws pertaining to employment are always changing. There's new legal precedents being set every day. So I'm just kind of warning you that you probably aren't going to be happy about the trends that we're talking about today, specifically what you as an employer might do to an employee that can later be considered retaliation. It's a pretty broad definition. So my goal today is just to make you aware of what's been going on in hopes that that awareness will help you to avoid costly mistakes or missteps and hopefully reduce the risk of litigation. And that being said, I just have to do a 10-second disclaimer that the information I'm sharing with you today is really for information only. It's not for the purpose of providing legal advice. I'm not an attorney. These are really my opinions based on my own experience and my knowledge of recent court decisions related to HR. So now that I'm sure that you won't sue me, we can get started. And I think that those of you who handle HR are all familiar with this employment at will doctrine. So we'll start with something that we all know. The employment at will doctrine basically allows us to terminate an employee at any time for any reason or for no reason at all. And we've always taken great comfort in that, and it sounds great. That doctrine gives employers in the United States, anyway, more discretion than in most other countries where the employers required to prove just cause in order to file employees. So we're fortunate in that this one aspect of U.S. labor law favors employers and is pro-business. But what we're talking about today is the fact that this is slipping away. There are so many exceptions or limits to employment at will. Our topic today of retaliation is really about those limits and about how our hands are becoming increasingly tied in terms of how we can respond to employees, not just in terms of terminating them, but in other responses to them as well. So if there is a reason that runs afoul of the law, of labor laws, it's always been the case that you cannot fire a person for a reason if it's illegal, if it's discriminatory, if it's because they're pregnant or because of the color of their skin or because they engaged in whistleblowing activities. That's not changed, but today we'll talk more about how that list of protected activities is growing. And as well, in a few minutes, we'll talk about, as I said, not only our ability to terminate an employee that's being eroded, but such simple, seemingly innocent actions that you may take, such as making a change to an employee's schedule that can even rise to the level of legally qualifying as retaliation. And these first few slides, it's a little bit abstract and confusing. In a few minutes, we'll get into some actual case scenarios. So the bottom line here is once an employee makes a complaint, maybe they say they've been sexually harassed or discriminated against because of their race, or maybe they say there's a hostile work atmosphere, or maybe they go out on a medical leave, or they file a workers' comp claim, whatever. All those things are protected. Employees are protected. That's within their rights to do those things. So once that happens, almost anything you do might qualify following that complaint being made or the leave being taken or the workers' comp claim being filed and so on. So retaliation really, when it boils down to it, is the unlawful payback for something legal that the employee did. So I remember in the old days when I first started working at Bow New England, if an employee made a complaint, it wasn't unusual for a manager to feel that the best strategy would be to write them off the schedule. I don't know if you're familiar with that phrase, but it's a non-confrontational way to sort of get rid of somebody that you feel is a troublemaker. And we can't do that anymore. We can't get away with that anymore. There's a lot of things we can't get away with anymore. And, you know, if somebody asks for an accommodation through the Americans with Disabilities Act and subsequent to that you ended up, you know, writing them up for things, that even can be problematic. So it's not so much about the complaint that the employee files itself, it's about the legal implications that arise from your response to it. So we're going to be delving into, you know, why you can't basically get away with these things anymore. We used to do a whole host of subtle things hoping somebody would quit. And now, you know, those are no longer wise, especially legally. So let me see if I can advance this. For some reason, it's not advancing.
Slide's not advancing here. I can move it for you.
Yeah, it's just stuck on this.
I moved it to the next one's the poll. Do you want me to run that poll?
Oh, sure.
And then you can try to take back your screen, take back your control there while this poll is running. Jane has voted here a poll you'll see on your screen. Whether you're on a mobile device, you can just touch the screen and submit, or if you're on a computer desktop, just select which you feel is the correct answer for your business. Has your company had anyone accuse you of retaliating against them? If you could submit your position. We got about 50% of you have voted. Time to wake up, come back to us, stop checking your email, come back and take the poll in there. And Jane, I don't see that you have control. Did you try to take control again? To go ahead and
try to take control, Kelly. I always try to take control. But something's not right.
Of the screen. Maybe it's the poll itself that's causing, but as soon as maybe I bring the poll down, maybe it'll give you back that control.
Okay.
Good. So I've got about 80%. I've still got a few people who haven't voted here, giving us their opinion. I think it may surprise you here. I'm going to see if we can get a couple more here. We've been going 1 minute. Give them another 10 seconds here. See who's actually not paying attention or maybe just doesn't have
multitask.
Yeah, they can't. Hey, I'm not a multitasker. Trust me. I've got to be focused on this and nothing else. All right, so I'm going to close that poll. It doesn't look like anybody else is going to jump in. And I'm going to share the results here for you. Here's your results. Dan, you should be able to see those on your screen. Does that surprise you, or is that normal, or what's that for you in your side, your opinions?
How many were yes? I don't see it.
Oh, you don't have it on your screen. Really? It's we have none that are an absolute yes, they took legal action. We have 27% who said yes, but no legal action. And the remaining 73% was no, never had anything in any way.
Well, you know, I'm thrilled because it is an area of HR law that is exploding right now. And perhaps by, you know, becoming more knowledgeable about it at this point in time, you can prevent it. But it's nearly half of the claims filed with the EEOC right now are retaliation claims, not discrimination claims. So the timing is good in terms of folks making themselves more aware of it.
Okay, it's a chance maybe you got knocked offline, so I'm just going to advance you to the next slide. And if you can't advance it yourself, let me know and I'll advance it for you. That's the backup plan we had in place, and if we have to use it, we will.
Yep. So the next slide is the new twist on getting sued, if you're able to advance that.
It's already there, already up there and see, because you obviously can't see. So you must have
okay, so you know what? We're going to wing it because I don't see it. So we'll just So we have the list on the left of in the old days. Formerly, we were concerned about getting sued for blatant discrimination, mostly involving, you know, the Title VII series of anti-discrimination statutes, you know, racial discrimination, religious, sex, national origin, age, pregnancy, those kinds of things. And today, there is a huge risk from employees who claim you retaliated against them for making one of those complaints. The list on the left are all protected activities, and employees have a legal right to assert those rights. So in addition to the top few, there's a few at the bottom that they legally are have a legal right to request a Family Medical Leave Act, an accommodation through the Americans with Disabilities Act. You know, if they're misclassified through the Fair Labor Standards Act, workers' compensation, all those things involve protections and rights for employees. And again, your response to those things may rise to the level of qualifying as retaliation legally. And as I said before, it's become so broad, almost anything that you may do as an employer can rise to the level of retaliation. So why don't we go to the next slide. This is just the HR update. It's just a screenshot that it's an email that I received recently that I thought was really eye-opening. It just serves as a warning, particularly to HR managers regarding this issue of retaliation. As I mentioned, it's gotten to the point where 44.5% of all complaints filed with the EEOC are retaliation complaints. It's doubled in the past decade, and we're going to talk in a moment about why that is. Racial discrimination, I believe, is still number one, but the primary reason for this increase, and this is really important, is that it's much easier to win a retaliation case than it is to win a discrimination case. So even if the employee's complaint, if they say they've been sexually harassed or discriminated against based on something that's protected, even if that is without merit, totally baseless, your response to that can still rise to the level of retaliation, which is incredibly frustrating. Hey, I just got my screen back.
Hey, great. Oh, look, you did it on your own. Awesome.
Okay, I guess I'm in control again.
Yes, you are.
So this is where it gets interesting in terms of how we got to this point where your hands are tied in terms of anything you might do in response to an employee after they've filed a complaint or gone out on a leave or engaged in one of those protected activities. So retaliation has become incredibly prevalent, in part because of this famous lawsuit that started in 1997. It went all the way to the Supreme Court in 2006, I believe, and it changed the definition of retaliation. It used to be very specific, and it's become extremely broad. So this is an interesting suit that involved a woman named White. She was hired by a railroad company, and her job involved operating a forklift. And her supervisor made some what we call stray remarks. So perhaps he said something like, "That's no job for a woman." She complained. It was a formal complaint she filed with the EEOC, and her the employer, the railroad company, suspended that supervisor for 10 days and had him participate in a sensitivity or some sort of harassment training class. So it was kind of a slap on the wrist, but that's a standard response that companies might do when someone is, you know, charged with harassment or sexual discrimination. They often end up just giving that supervisor a slap on the wrist. What happened in this case was that the woman, the forklift operator, she was reassigned to a different position. And again, it's not unusual for a company to reassign someone following these kinds of complaints because you want to separate the supervisor from the employee. So it's fairly common to do those separations. But she claimed her new assignment was beneath her. Those aren't her words, that's my phrase, but she felt that her capabilities were not being fully utilized because she was no longer driving a forklift. That was her thing. She didn't have a change in pay. She didn't have a change in work hours. She was just reassigned to another position, same rate of pay. You know, she clearly wasn't fired. And so it used to be, before this precedent-setting case, it used to be no harm, no foul. If you didn't reduce their pay or fire them or do something really bad that was blatant, that you couldn't get in trouble legally. But when this case was heard by the Supreme Court, you know, and she claimed that they were putting her in a different role that didn't involve forklift operating, that amounted to retaliation. So she claimed discrimination and retaliation. She said that they were retaliating against her for filing the discrimination case. And even if the pay is the same, the action taken by the company in this case was deemed materially adverse. That was the phrase that the courts used. and they said it did constitute retaliation. It was punishment or payback for her filing that complaint. So now we have this huge can of worms that has been opened. As I said, it used to be no harm, no foul. You had to, reduce someone's pay or fire them. And now they've just put her in a different job, and they decided it did constitute retaliation. So working beneath her ability, that's really broadened the definition. So it's as a result of this case that the definition has become so broad that almost anything you do after an employee engages in one of those legal activities that we just looked at, it can get you in hot water. So it's interesting to note that in this case, the woman, whose name was White, she did not prevail in her discrimination suit, but she did prevail in the retaliation suit. So it's a classic example of even if the initial claim is without merit, or they don't feel that it rises to the level of discrimination or harassment or whatever it might be, your response to it can still get you in trouble and can still constitute retaliation. So I'll have Kelly advance me to the next slide because it's not moving. Oh, did I do that? I guess there's just a little delay. Sorry about that. So after that, since that precedent-setting case, the landscape has changed completely. To be considered retaliation, it's almost any adverse action that's taken against an employee following a complaint or going out on leave or filing a workers' comp case, all those things. So it used to be you had to be fired or demoted or have your pay reduced to constitute an adverse action, and it wasn't retaliation unless it was one of those things. But now, it's pretty unbelievable when you look at this list on the right side of the screen. Since White versus Burlington Northern Santa Fe, the definition is so broad that even if you change a work schedule, let's use an example. You have a bartender or a server, and at some point recently she asserted her legal rights, and maybe she said she was being harassed, or maybe she went out on a leave, whatever. And then you decide to change her work schedule, and it turns out that that new work schedule maybe is less lucrative in terms of tips. Maybe she used to work on a busy league night, and now she's been reassigned to a quiet shift, so she's making less money. Or it could be a schedule change that's problematic in terms of getting child care. Or it could be a conflict with a class schedule for someone who's attending school. It's in the eye of the beholder now. If it is an adverse impact on that individual person, it can constitute retaliation. So the next example is a lateral transfer. So even if the money is the same, if the job is considered less desirable, or if the responsibilities are different, as in this White case where she wasn't utilizing the same skill set, working conditions also can be considered retaliation. So if someone engages in one of those activities that they legally have a right to do, and subsequently you say move them to the warehouse and they used to be in the office, or maybe in your case it's from one center to another and they perceive that as less desirable, maybe it lengthens their commute, or for whatever reason it's less desirable. If you give someone a negative review and it's soon after they filed a complaint like that, and this is very, very common because the GM has always been taught you need to document things, if you're going to fire somebody, and the GM wants to lower the boom, and he's labeled someone a troublemaker, so he figures now I got to start the documentation process. But if it's following a complaint, it looks fishy. And we actually read about that example all the time, that somebody, is trying to prepare the file with documentation, but there was no documentation prior to them filing the complaint or having the workers' comp claim or going out on family medical leave act or whatever. The other thing that's very, very common is now all of a sudden after somebody's complained or done one of those things, that there are warnings now being issued. So the person is late for work, the GM says, I'm going to write them up for being late. but you have 5 other employees that are always late that aren't getting written up, or that are chronically late. Again, it looks really fishy. So you can't do warnings selectively. All these things that managers, as I said, used to engage in hopes of getting somebody to quit, basically. You know, they would come up with these subtle things in hopes that they would quit. The last thing on the list here is pretty shocking, too, that excluding an employee who has made a complaint or engaged in one of those legal activities, if following that complaint they are isolated or they're not invited to things that they were previously invited to, maybe it's the big meeting, maybe they're no longer given a seat at the table when they had always participated in a decision-making way. All these things that are subtle, as I said, it used to be no harm, no foul, but now all these things are being considered, that they rise to the legal level of constituting retaliation. It looks like, and again, unfortunately, this is all about what it looks like. And even if your intentions are good, it looks like you're imposing a consequence on that employee for making the complaint. And the courts believe that these actions serve to discourage other people from exercising those rights. So if you had an employee who, you know, went out on Family Medical Leave Act, and when she came back, she was reassigned to a less lucrative shift, for example, it kind of sends a subtle message to other employees that that's what happens when you go out on Family Medical Leave Act. So that's some of the motivation in terms of the courts feeling like all these things that now constitute adverse action serve to discourage other employees from exercising their rights. So if we take a step back and just simplify, the easiest way to describe retaliation is really that it's action taken by the employer that's viewed as punishment by the employee, or payback, and it's in response to them exercising any right that's legally protected. There's huge out-of-court settlements taking place, and when it goes to court, we know that it's heard by a jury, and we know that juries are made up largely of employees, not business owners, and they tend to be employee-friendly and sympathetic, and they view the company as the evil empire. And it's also problematic that some of the laws, it's not clearly defined in terms of exactly which legal activities are protected, and lawyers love that vague language. The bottom line is, and I said it's unfortunate, but what matters and what you need to be concerned about is how it would look through the eyes of a jury. I guess every once in a while I like to give a little bit of good news. I did read a case recently where the employee complained, and I don't recall what type of complaint it was. It was legally protected, but they said that the employer retaliated against them because they delayed their expense reimbursement check. Okay? So the court ruled that that was a minor annoyance, and it did not rise to the level of retaliation, thank goodness. You know, but the definition is quite broad, and I thought it would be helpful if we went through some actual case scenarios and looked at whether or not certain things constitute retaliation. So let's consider, and Kelly, I can't seem to advance, Anne goes out on Family Medical, sorry. Yep. Did you do that or did I do that?
I did that for you, but you're okay. Nope, now you did it.
Okay. Sorry.
There's Ann again. You're all set.
Yep, there's Ann. So let's consider some real life examples and see if the employer's response to somebody exercising their legal right could be construed as retaliation. In this case, Ann uses Family Medical Leave Act to go out on a leave. She has a serious medical illness, or maybe it's a parent or a child that has a serious medical illness. But when she returns, she's reassigned following that leave, and she's told that the old position was no longer needed. The new position involves duties that she considers to be below her capabilities. This is not unlike the forklift operator in White versus Burlington Northern, in that she was reassigned to a different role that she felt was below her capabilities. So each time you have a scenario, there's 3 questions that you need to ask yourself to decide if this may be viewed as retaliation. So the first question is is it protected? So the activity that the employee engaged in, is it legally protected? And what she did, taking FMLA, is protected. That's a federal law. So in terms of asserting her rights to utilize the FMLA leave, it's just like somebody asking for an accommodation for the Americans with Disabilities Act. It is protected by law. And then we say, was there adverse impact? Well, we used to say no harm, no foul. We didn't change her pay and we didn't fire her. But now, because of that precedent-setting lawsuit that went all the way to the Supreme Court, we can say yes, that could be considered materially adverse to that employee. And then the third question you need to ask yourself is there a causal connection? So the court says they get to decide if there's a causal connection, but it certainly looks bad if Ann has worked there for 5 years and other people may be still working in that job that she was moved out of, for example. They would take all those things into account and determine if the adverse impact resulted from her filing that complaint or going out on that leave. So the next example we have is Andy, and Andy complains either, he says he's not being paid overtime correctly, maybe he goes to his GM with his pay stub in his hand and says I should have gotten time and a half, or perhaps he believes that he's been shorted a few hours at straight time, whatever it is. Andy may even refer to that's illegal, which of course sets off red flags with the GM, right? The GM starts to feel he's not a team player. He's made this vague reference to the labor board or a vague reference to I'm going to report you, whatever. But once the GM is concerned about this person not being a team player, the GM waits a month or two and gives Andy his first ever negative performance review. And that review could possibly impact his future career growth. So we'll ask ourselves the 3 questions again to determine if this situation might qualify as retaliation. So is he complaining about something that's protected? Well, paying people for hours worked and paying them correctly and paying them time and a half for overtime is part of the Fair Labor Standards Act. It's protected. So the answer to number 1 is yes. Was there an adverse impact? Well, suddenly, this is the first time he's ever gotten a negative review, and it could impact his future career growth. So yes, there is an adverse impact. The causal connection, again, is what the courts will decide, but it does look bad if Andy's worked there for 4 years and he's always had positive reviews. It looks bad if there was never any documentation of serious performance issues and now suddenly he's getting written up. It looks trumped up, and the courts are far more sophisticated than they used to be in terms of saying you're just setting somebody up in hopes that they'll quit. So the next one that we want to look at is, we'll call her Donna, and this really happened to us. She worked in the food and beverage area at a walk-up counter, and she expressed interest to her GM in pin chasing. And the manager, in his infinite wisdom, questioned whether she was physically cut out for the job. Okay, you'd think we would know better by now. Even if you think those things, you can't speak those things. So Donna complained to that GM saying, you know what, that's discrimination. And to himself, now the process starts to unfold. The manager says, oh, geez, she's trouble. She used that word discrimination. That's a red flag. I got to get rid of her. Or I got to do something. She's a troublemaker. And this part didn't really happen, but I had to create a fictional example. The manager changes her schedule or writes her up for being late. He's never written her up before for being late, and he doesn't write up other people for being late. So we'll ask ourselves those 3 questions. Is it protected? Well, Title VII protects people from gender discrimination. And that comment would not have been said to a man. Was there adverse impact? Well, she's not being given an opportunity to step into a field that she's interested in. So yes, there is adverse action taking place there. And then there's also adverse action taking place because now she's getting written up and maybe he's scheduling her for fewer shifts, the old strategy of writing somebody off the schedule. Then the court decides, is there a causal connection? Is it because she complained and said it's discriminatory that these things are happening to her, that her schedule is being changed, or she's being written up for trivial things that nobody else gets written up for? It looks like suddenly she became a problem when she brought this illegal activity to the attention of the manager. And again, it looks bad, looks like you're setting someone up in hopes that they'll quit. This example, we'll say that this person was fired in retaliation for filing a discrimination complaint. I'm going to change it up a little bit here and say, even though the server in the picture looks young, let's just say it's age discrimination. I want to caution everybody about the danger of stray remarks, because, you know, we all joke around in the workplace and we feel like we know each other well, but then when the employment relationship goes sour, these things come back to haunt you. And in this scenario, we'll say that comments were made, like, you've been here since the dinosaur age. When are you going to retire? You're as old as the hills. And even if she laughed at the time, if she remembers those things, she writes them down, and then the employment relationship goes south, she can charge age discrimination, and she has witnesses who heard those comments being made. So if she complains about age discrimination, and then suddenly she gets written up, maybe she's got a shortage in a register, or maybe she's been late a few times, the manager, again, is thinking that he's smart by starting to document this, but he's either got to document everybody consistently for those things, or he's got to start documenting problems before people make these complaints or go out on leaves or file workers' comp cases. So in this situation, she's fired after the third warning. That's what we were always taught. And there's the lawsuit for age discrimination and retaliation because of the write-up that she was given. So the employer was required to produce all other written warnings issued to other employees for similar infractions back to 2009. Guess how many they had? The 3 that she was given. You know, it kind of makes you squirm, but that's good, because that means we're getting somewhere, that you can't do that stuff. You can't just suddenly start writing somebody up after they've filed the complaint if you don't consistently write other employees up for the same infractions. So the 3 questions we ask ourselves: is it protected? And the answer is yes. There's laws against age discrimination in the workplace. Is there adverse impact? Well, termination is the most serious form of retaliation of anything that you could do to somebody. So definitely adverse impact. She got the 3 write-ups and was terminated. And then, was there a causal connection? And again, the court is going to instantly say that something is suspicious if we haven't treated other people the same way for the exact same things, and that all this started up suddenly following her complaint about age discrimination. So we want to beware of what they call coincidence liability. So if the employee has recently filed a workers' comp claim, or taken a protected medical leave, or requested some sort of accommodation, maybe they claimed they were being harassed, maybe they claimed it was a hostile work environment. If they're subsequently adversely impacted by something you do as the employer, it looks fishy, and judges and juries are super suspicious of these amazing coincidences. So if something changes following a complaint, if the reviews suddenly become negative, warnings are suddenly issued, work schedules are suddenly changed, if the person is isolated, or maybe you skip their pay increase. Again, a lot of this can be prevented if you've done a good job of managing people in the first place. And if they have performance issues and you document those performance issues and you have things in place before complaints, it doesn't look fishy. But what looks fishy is all of a sudden these things begin to happen. So oftentimes people say, well, what's the safe amount of time to wait after somebody has filed the complaint? And I don't think that there is an exact answer for that, but I have read attorneys saying that although there's no hard and fast rule, they say wait 6 months after an employee has taken a leave, filed a workers' comp case, made a complaint, before you take any sort of action. So this also happened to us. We had an employee who was terminated, and after she was terminated, she filed a complaint. So it's confusing in this scenario because she was terminated because she stole some of our game cards. We have that intercard system in the game zone, and we have promotional cards in the corner of the office. They're set aside in a pile. I think there's a $5 value on the card, and we use them to give out at birthdays. And this employee stole a handful of cards, and then she went out and played the games. I think it was the Wizard of Oz. It was on surveillance video. She then took the points that she earned on those cards and combined them onto another card that would be more difficult to trace to her. So she was caught red-handed on video. She was on the clock. The surveillance camera has a time and a date stamp that corresponded to when she was clocked in. The intercard system provides a lot of documentation as well. But when she was fired, she went and filed an unemployment claim. And then she claimed that she was fired in retaliation for being pregnant and planning to take a leave. So we thought about this. I mean, it made us nervous, but at the same time, would we fire anybody who stole the cards, played the games, combined the points, and was caught red-handed? The answer is absolutely yes. So we weren't willing, to step back and say, that she shouldn't have been terminated or anything like that. It had nothing to do with her pregnancy. We had known about her pregnancy for a long time. So I guess the message here that I want to make clear is that beware unemployment rulings, because if you let that stuff go, oftentimes, you don't want to create waves, so you might allow an employee to collect unemployment rather than contesting their eligibility. But if this person claimed on her unemployment claim that she was fired in retaliation for being pregnant and planning to take a leave, and we let that go, and now there's sort of a judge's ruling on that, they can use those rulings as fodder for another lawsuit, and they feel empowered. Wow, I got my unemployment. The judge that determined my eligibility said, agreed that it might be in retaliation for being pregnant. Maybe I should go talk to an attorney about filing a lawsuit. So you can't you can't let the unemployment claims go. I just had a hearing this morning regarding someone who claimed that they were terminated as a result of filing a workers' comp case. And there are times where we say we're not going to contest somebody's unemployment, but once they make that connection, you have to. Because otherwise, now you have a judge who's sort of put a stamp of approval on that connection, and it can come back to haunt you in the future. So in this case, we felt that there was enough there that we terminated her despite her being pregnant without fear of a lawsuit. And again, I advise you not to let it go and let them collect unemployment if they're making these kinds of connections on their claims. So, I don't know, Kelly, do you want to take this poll?
Well, I've got it already up there, so let's go ahead and do it quick.
Okay.
We'll give them 60 seconds. This is great stuff, and I have to tell you, we try to keep our webinars short, but we have 80% participation activity at the 40-minute mark. We are flying. Everybody's still engaged. You've got them captured. So
Okay.
we are just.
And we don't have much left.
I know it's fabulous to see. The fact that this topic is becoming more and more relevant as we move forward in the world. I think we're a little bit ahead of this, and those of you who are here are ahead of the curve in paying attention to this stuff, because it's going to become more relevant as time moves on,
right?
And more so than the past has been. I've got about 2/3 of the people who have voted. Give them just another 10 seconds here to vote. So if you haven't voted yet, please do. And thank you for becoming more attentive. I know you're trying to eat your lunch and do all that, or those of you on the West Coast, you got to rub the sleep out of your eyes. We appreciate that. But there we go. We got everybody here. I'm going to close this now. I think we had one less person this time than last time. I'm going to share your results. And again, don't know if you can see those, because last time you had difficulty seeing them. I'll just read them to you. We had No yeses. Nobody has taken legal action. We have one yes. They verbally indicated they would file a complaint, and then we have 31%, and then 69%. No employee has mentioned or filed a complaint against our organization. I would say that from what I've learned from you, that trend, if we did the same webinar 2 years from now, those numbers would be
Right.
significantly different.
And you know, I definitely know that we've had employees that sensed they were on thin ice, and then they either, you know, fell and filed a workers' comp claim that maybe was a little bit staged in hopes that it would tie our hands. I often get nervous when the timeline is prolonged, when we've made a decision to let someone go, because if they get wind of it, they may definitely do something. You know, I definitely remember a case where I was on my way in the car to let someone go, and she sent me an email saying she was being sexually harassed. You know, we did move forward because we had what we needed to have, but in many cases you don't, and then you're really stuck. So I think I have control again. Do I?
You do? Yep. Do you want to do your example there, excluded in retaliation? There you go.
So you're seeing things probably 10 seconds before I am. I still have your poll, but if it has, is it retaliation on the screen?
It's
hostile work environment?
It is the examples excluded in retaliation for hostile work atmosphere
Perfect.
complaint.
Okay, I still see the poll. I guess I'm on the slow one. But anyway, we had said earlier that exclusion now constituted retaliation. So if you are not inviting people to the meetings or not, you know, giving them a seat at the table, and previously, prior to filing a complaint, you had given them a seat at the table and included them in meetings. So this is an example of someone who claims that he was retaliated against by being excluded after complaining about a hostile work atmosphere. So this one seems the most far-fetched to me, but employees have won retaliation suits like this, and when I think about how society has changed and what we once considered sort of harmless joking, teasing, or the bullying that went on in the playground when I was a kid, it's just no longer tolerated. Society has definitely changed. You know, schools have zero tolerance policies for bullying. The way that managers behaved, you know, in the 60s and the 70s, much of what went on then is no longer legally allowed. In this case, we'll say Tom was given an assignment, and he messed it up. There was no question about that. Maybe he had unacceptable results or missed deadlines or whatever, but his manager lost his temper, used threatening, bullying, offensive language while reprimanding him. And again, there may be people out there that are listening to me that are squirming now, because we often have people with anger management problems. They're stressed out. It's a hard job. So Tom complained to HR. He claimed a hostile work environment, and employees are actually now familiar with that term, hostile work environment. And I've probably had it come up 3 times in 6 months for situations like this. So the manager, perhaps after being counseled by HR, apologized to Tom, but now he's openly hostile. So he nitpicks everything Tom does. He doesn't invite Tom to the next few monthly meetings. He's really sabotaging him, and he's really hoping he'll quit. And again, these are the things we can't get away with anymore after someone has made a complaint. So the 3 questions we ask ourselves: is it protected? Well, hostile work atmosphere or environment is definitely a law. The law protects employees. And unfortunately, with a hostile work environment, the definition is a reasonable person standard. So if a reasonable person says that that behavior constitutes a hostile work atmosphere, then it does. The adverse impact, while he was isolated or excluded, it's subtle, but they're not inviting him. I use that expression, a seat at the table. He's definitely felt a shift since he went to HR and said that he felt that he was involved in a hostile work atmosphere. So if there's ever a substantial negative change following a protected activity or a complaint, in this case, you know, a hostile work atmosphere, you have to be very, very careful about how you proceed. And it's very hard to repair these situations, you know, to get Tom to sort of step back and start over again. I'm sorry, the manager to step back and start over again with Tom, as opposed to harboring resentment towards him for you know, making the complaint. And I think one of the major points here is that inconsistency will kill you. And that's always been the case in HR, but when you issue warnings, have warnings been issued for all employees who have had similar infractions? So if somebody is late and they get written up for it, are you writing up other people for being late? I mentioned that case where the employer had to produce all other warnings issued to other employees back to 2009 for similar infractions, and they had none. It looks pretty bad. It looks pretty trumped up. It looks pretty fishy, coincidence, liability. When warnings are issued after the complaint and none were issued before the complaint, it looks pretty fishy. So I did want to point to some management practices. They're just, you know, good management practices, but it's all part of educating and training your GMs on how good management practices help to minimize the risk. And being consistent is what I've been talking about. You can't select people to write up, you know, for being late because they've recently complained about something. Documenting performance is always been the case. So you can't be blackmailed by somebody who says, you know, something has changed because I just filed a complaint. You can say, no, we've spoken about this in June and it didn't improve, and we spoke about it again in August, and here it is September. You know, you're on much more firm ground if you've documented something prior to somebody engaging in one of these legal activities, a complaint, workers' comp, whatever it might be. Documenting conversations, even if that means emailing a summary of a conversation to an employee after you've had a discussion about performance issues. Sending a strong message really refers to you as the GM or the owner setting the tone at the top. And I referred to stray remarks. We all like to have fun at work, but that employment relationship is going to go bad at some point, and those things come back to haunt you. Being discreet just refers to when people do file complaints and you have to do an investigation, don't let it become a source of gossip. You need to limit it only to the people who are directly involved. And then number 6, waiting for a second opinion. This is something that I learned from one of our district managers who had worked for many years at another company. Basically, this means before you terminate somebody, suspend them pending review from HR. So as I said, that the most serious thing you can do to an employee is terminate their employment. And if something happens, we tell managers to keep this in your back pocket. You need to clock out and go home. We'll get in touch with you regarding our decision pending a review from HR. So nobody makes termination decisions on the fly. Avoid stray remarks. You know, as I said, you know, we like to have fun at work, but if you joke with somebody, that's no job for a woman, it's going to come back. So we always look at things through the eyes of a jury and what a jury would consider to be fair, and would it look bad in the eyes of the jury. Now, this 6 months, as I said, is not a hard and fast rule, but I've heard attorneys refer to it in terms of not doing anything to an employee following them lodging a complaint, going out on a leave, etc. And then not promising to keep things confidential. I just mean if somebody says they're being harassed, you need to do an investigation, and that means talking to the parties involved. The employee is basically tying your hands if they don't allow you to do that. You need to speak to other people when you're investigating complaints, but only people who are involved. And then I just have a final slide that has some additional reference material. It's a U.S. government website. There are some links there that help clarify what constitutes retaliation, and I'm hopeful that some of these case scenarios that we've discussed resonated with you, and that you've come away maybe with some more awareness of the risks associated with retaliation. And I'm looking at the clock and want to be respectful of your time. So Kelly, if there's time for a Q&A, we could do that.
Yeah, I have 2 questions that have come in. So just real quickly, if you could answer just these 2 questions,
Sure.
it'd be great. Unless anybody else submits one. If you guys have one, send one in. I know we are running a little long, but if anybody wants to go, nobody's gonna be hurt feelings here or anything. But we got, again, the attentive level. Everybody's still engaged. So this is awesome. The content obviously is resonating with the audience. So I have one. Joe from Florida here says, does the employee have to file a formal complaint in order to later claim retaliation?
That's a really good question. Unfortunately, the answer is no. The employee doesn't have to file with the EEOC. They don't have to put their complaint in writing. It just has to have been brought to the attention of management. So we know that managers are agents of the company. That's all that's needed. And it can even come to you secondhand. So if Mary tells you that Sarah feels like she's being harassed, now you know. Okay? So it does not have to be a formal complaint, and I'd say in most retaliation cases, a formal complaint hasn't been filed. They've just brought it to the attention of someone in management, and that's all that's necessary. Great question.
Wow. Wasn't expecting that answer. Now another one, Jay from Nebraska says, does any kind of complaint put the employee on safer ground regarding termination?
If I understand the question, there are certain complaints that have no legal implications whatsoever. So if somebody complains, I just have to make up a scenario. If someone complains that nobody's cleaning out the refrigerator in the break room, that's not in any way, shape, or form a legally protected activity. It's not Family Medical Leave Act. It's not the Fair Labor Standards Act. It's not Americans with Disability. It's not, Title VII anti-discrimination statute. So it has to be something that's legally protected in order for you to subsequently run the risk of retaliation and how you respond to it. You can fire somebody for complaining too much about not cleaning out the refrigerator in the break room.
Well, that's good to know. But, great stuff. I don't have any other questions. I'll give you one last chance here. I know we're almost 10 minutes over, but it's just fabulous content, and it was great, and everybody's still here. I don't think we've had anybody leave. If there's any more questions, please forward them to me. You can email me at education@bpaa or directly to me at kelly@bpaa.com, and I'll certainly forward those on to Jane. We did have a request for the slides, the actual presentation, but I think of a better value is we did record this session, and you can watch the entire session for yourself, either at our YouTube page, the Bowling University YouTube page, or at bowlinguniversity.net. We post those with all our webinars, as we always do. Those should be up by tomorrow. So great questions. We appreciate all of you taking that extra time to stick with us to the very, very end. And one more time, Jane, thank you for putting this fabulous presentation together and giving us another perspective and kind of getting out ahead of this stuff, way ahead of the curve that we wouldn't even have thought of if you hadn't brought it to our attention. So thank you.
Sure.
And thank
Anytime.
you, the company, for loaning you to us for this time over this period of time. So one more time, just a thank you for you and to everyone else. That concludes our session for this time, and we hope you'll join us for our next webinar that we have on the schedule for March. And there'll be a little survey as you leave. We hope that you'll take that survey and help us out making these webinars as good as we can for you. Thank you again, and have a good afternoon.